5, 4, 3, 2, 1. The fulcrum of the arguments of the learned counsel for the respondent number 1 is that in the earlier suit filed by the respondent number 1, petitioner had sought to intervene and his application was dismissed, holding that he was neither a necessary nor a property party, and said dismissal has been upheld up to the Supreme Court. The plaint of both the suits has been placed on record. Perusal of the plaint of the earlier suit filed by the respondent number 1 shows that respondent number 1 at that stage was seeking to place an iron shutter on the window which already existed on the southern side. Respondent number 1 was not at that stage seeking to open a door or a business opening to his shop. Since respondent number 1 was only seeking to place an iron shutter on the side of his shop on an opening which was already existing, said relief in the first suit is clearly distinct and different from the relief sought in the second suit, which is the present suit. In the present suit, respondent number 1 seeks to open a door as well as give access to his shop from the side which faces the kiosk of the petitioner. In case respondent number 1 was to make an opening and keep his articles outside the shop, it would certainly impinge upon the passage between the shop of the respondent number 1 as well as the kiosk of the petitioner. In that view, it cannot be said that the rights of the petitioner would be completely unaffected if an opening were to be opened on the southern wall of the shop of the respondent number 1. The argument of learned counsel for the respondent number 1 that the application would be barred by the principle of res judicata is not sustainable in view of the fact that the relief sought in the first suit, that the relief being sought by the respondent number 1 in the second suit is clearly distinct from the relief sought in the first suit. In the first suit, the respondent number 1 was merely seeking to place an iron shutter over the window which already existed. From the said window, there was no access available to any individual into the shop, but now respondent number 1 seeks to open a business entry towards his shop from which customers could also enter, which would have bearing on the rights of the petitioner. So it cannot be said that petitioner is neither a necessary nor a proper party to the present proceedings. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.